issue notice, as we are of the opinion that the question of that the truing up insofar as what was the first cause? Fuel surcharge?
No, the first is fuel surcharge.
Fuel surcharge.
That's right.
Was subsequent to the commencement of this proceedings, before the adjudicatory commencement of the proceedings under section 53C of the Insolvency and Bankruptcy, 54C of the Insolvency and Bankruptcy Code 2016. So stop. The same would be also correct as far as.
It's factually, Manoj, that may not.
But the same would be also applied as far as special fuel surcharge amount is concerned. Stop. Our learned senior advocate appearing for the appellant, Sri Rajasthan Syntex Limited, had relied upon 2022, raising the said demand. Stop. However, during the course of hearing, it was accepted that in form number 10C, the amounts referred to in the notice to order dated 20th of September 2022 were not included. Stop. That being the position, we do not think the review judgment requires interference by this court, and accordingly the appeal is dismissed.
Deeply grateful.
Triple models.
Your Lordships,
My lords, apologies. We had mentioned this matter yesterday and today morning also. The
Yes.
thing is, the client had very specific instructions that they wanted to brief a senior. So even though we're
What is there? Yesterday we said that if you want, you could not issue notice. So let it, we say the notice will be issued without Wakalatnama, that's all.
my lords, notice will be issued.
Without Wakalatnama, that's all. That was the issue.
No, my lords. My lords, what had happened was, my lords, this is an SLP that comes against the dismissal of a 711.
Oh, okay, no, okay. That's the transfer petition. That's a separate matter.
Yes, my lords.
The 711 has been dismissed, so what
Yes.
can be done?
So, my lords, the problem is this matter was in defects. My lords, it had gotten listed yesterday as part of the Waqf matters, and that's why yesterday it was detagged.
Okay,
My lords, because it was
right now.
so, my lords, may adjourn it
Petition of
next.
the council for the petitioner relist in the week commencing 28th of July 2025.
My lords, that may be.
No urgency.
No, my lords.
711 dismissed. Suit will proceed in its own
No,
pace.
my lords may just, my lords.
Suit will proceed in its own pace.
My lords, the issue, my lords will just see one thing. The fact, my lords, here is that in the order, that
Where does the suit get over in 3 months?
because it is clearly barred by limitation. My lords, there is a 60-day period which the High Court does not.
We'll examine it on when it comes.
My lords, if I can then show 2 pages. If my lords, just 2 pages.
You're not arguing. You wanting an adjournment? You can find us.
My lords, the date. My lords, may then give first week July, my lords.
It's second week, third week of, second week is right, correct? Because first week will be the miscellaneous week. Next case.
Lordship.
This is that case.
There are about 21 petitions being asked for transfer, and almost everybody except a state of Jharkhand official respondents service is awaited. So Lordship may consider it withdrawing all the petitions because these petitions are here. And
What is the issue here?
that Freedom of Religion Act, my lord, in different states, which is subject matter here, notice has been issued to the parties in 32. Counter affidavits have been asked for, and these petitions were pending in the High Court.
Lords, there's only one issue seeking transfer of. Some of them are private parties. This is a PIL petitioner who's come
Only-
seeking transfer of petitions pending in the High Court, some which are by private, some themselves are PILs.
Just-
So notice may also be issued to those private
It
petitioners.
has gone. Notice has gone, my lord, except one person in the entire 21 petitions. Everybody's notice has been sent already.
The week commencing. Relist in the week commencing 21st of July 2025.
Lord,
I'm little doubtful whether this a transfer petition allowed. It may have a lot of consequences because the language of the sections are different.
my lord,
And
was in fact, if your
because
lordship
and,
has-
and handling them all in the Supreme Court with different enactments may be very difficult.
they are already sub judice here.
Maybe. Therefore, I
Notices have
said,
been issued.
let it come up afterwards.
Your lordship, may I say one thing? I am not saying anything, my lord. Just your lordship may have.
That's all,
16
please. We can't help it.
16th January
We have
2023
understood,
orders.
please. We have understood.
This honorable court wanted it to be filed, and that's
I,
it was.
I
filed.
therefore restrain myself. Next case. Because there are different
These-
enactments,
these-
no?
the
There are
other
different
matters-
enactments, the language will be different provisions will be challenged. And it's not a central enactment, it's a state enactment.
My lord,
Then should we call them over here?
all those
Anyway.
legislations are subject matter, my lord.
Hey, let's
Page
see.
36, I have given the entire
I'm
summary,
not saying anything wrong.
but those writ petitions are pending
Next
on the
case,
31st. Your lordship, may I make one more request? That they should not insist for any wakalatnama. They should number the petition, my lord. That's the,
What number the petition?
my lord, there is some objection because
Okay,
I.
it is pointed out by learned senior advocate appearing for the petitioner that the registry is insistent on the power of attorney stroke wakalatnama, which the petitioner is unable to provide for the reason that the petition has been filed, which the petitioner is unable to provide. To stop. In view of the statement made, the registry will not insist on the power of attorney stroke wakalatnama.
They may number the petition.
And the petition,
The
without
TP may be
insisting on the power of attorney stroke wakalatnama, will number the petition.
Deeply obliged. The other 32 petitions are listed on 30th. So your lordship may connect it with that.
30th of?
April, my lord. Yesterday it was listed as showing on.
No, let it come up, let it come up. Let it come up. Yes, please.
Lordship may connect it with that whenever that comes.
No, we will see. On 30th also we can, but
No, we can't hear you. Unmute yourself.
can you hear us, Mr. Gauri Shankar? Say yes by raising your hand. Can you hear us? Okay,
We are not able-
we cannot hear you. We cannot hear you.
Our side or this side?
There's problem, unmute yourself. Mr. Gauri Shankar, what we had said in the morning, I don't know whether you heard us. We are not inclined to entertain the present petition. If you want to file it before the High Court, you may do so. And on merits, let me put it,
It's not in.
you want to go to the High Court, yes or no? Okay. The petitioner appears in person seeks liberty to withdraw the present writ petition states that petitioner, if advised, may, if petitioner, if he desires, may approach the jurisdictional High Court by way of writ petition under Article 226 of the Constitution of India. In view of the statement made, the writ petition is dismissed as withdrawn with liberty is paid for. We have clarified, we have not made any comments either way on the merits of the writ petition and whether or not it should be, the issues raised should be examined.
Hello, hello.
No, this is yours, na, I made one.
हाँ 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 हाँ
नहीं, ये तो फाइनल में
हाँ
है।
May please, Your Lordship. Lord, I want to say something, Lord,
Yes, please.
with all responsibility, respect, and at my command. Lord, your lordships are going to consider whether to stay a statutory provision, whether directly or indirectly, my Lord, which is by itself
39.6.
Just
a
one-
rare occasion.
just 2 minutes.
Yes, yes. Hmm.
Yes, change this system.
Lord, I'm very respectfully urging, my Lord, as a Solicitor General representing the Union of India. Yesterday, my Lord, I have been working on this, my Lord, to answer your Lordship's questions. Lord, the questions are pertinent, my Lord, there is no doubt about it. But, my Lord, the difficulty is, and my Lord, I am putting it candidly before your Lordships, my Lord, knowing your Lordship's magnanimity. My Lord, these are not the issues, my Lord, which your Lordships may consider staying indirectly or indirectly, my Lord, based upon some prima facie or tentative reading of some of the sections. My Lord, we will have to take your Lordships to the history of legislation, 23 Act, which is 100 years back, followed by 35, followed by 54, followed by amendment in 84. There was a committee recommendation, followed by 95 and the amendment. And in the meanwhile, my Lord, we as a government and as a parliament, my Lord, we are answerable to people. We received lakhs and lakhs of representations, which resulted into, my Lord, some of the provisions being made. For example, my Lord, villages and villages are taken as waqf. Private properties of individuals are taken as waqf. I have orders which says when they approach the High Court that these are disputed questions of facts. Lord, it is a considered piece of legislation. Lord, the request is this, Lord. My earnest request. Lord, the petition is filed before the presidential assent. Lord, immediately, my Lord, it is being taken up. Your Lordships may take up, your Lordship must take up. I am requesting your Lordship to examine. Allow me, my Lord, allow me. And to be fair,
Just wanted to clarify, as far as the petitions filed before the president.
No, I'm not on
Is concerned, just ignore them.
ignore, I'm not, my Lord, saying, my Lord, but to be fair to them also, my Lord, to be fair to them, because it is a question where your Lordship needs assistance. Because it would affect, my Lord, either large number of innocent peoples, their right to land, their right to property, and at the same time, my Lord, some, my Lord, contentions with the petitioners are raised. And to be fair to them, my Lord, they also did not get, my Lord, sufficient, my Lord, opportunity or
We are not
satisfactory.
deciding the matter, Mr.
Lord, your Lordships are taking a very serious and harsh step, my Lord, in staying partly, indirectly, or in whichever way, my Lord, one may call it, my Lord, some statutory provisions without complete assistance, my Lord. My Lord, my request is this. I am coming directly to my request. My Lord, allow me to place within a week, and I promise your Lordships it would come before your Lordships within a week. My Lord, my preliminary reply, my Lord, some material with documents to show, statutes to show how this came into picture. My Lord, this is not, my Lord, with respect, my Lord, a matter your Lordship would also like to consider on prima
Mr.
facie
Mehta,
reading.
it's like this. We had a particular situation, maybe there are infirmities in that situation, and I put it across very clearly. Certain infirmities which were there. We also said there are certain positive things.
I understand, my Lord, I understand, I fully
It's not
understand.
that, and we, let me also very clearly put it, somebody did say there should be complete stay, we said nothing to, there's not, cannot be any stay. At the same time, we don't want the situation to change,
My Lord,
because, just one, we don't want the situation, whatever situation today is prevailing, change so drastically that it affects, it affects, no, please. There are provisions, like the provisions which you have enacted that 5 years. We are not staying that. We are not staying that because that can be dealt with. That can be, we're not staying anything like that. All that we want to do is, normally there, you are right, absolutely. One of the thumb rules which the courts apply, we don't stay the legislation at the previous stage. At the same time, there's another thumb rule also, that normally when the matter is pending consideration before the court,
Please
the
speak up.
situation as it is prevailing today should continue so as not to upset the rights of the party.
Please
So
take,
therefore, we
Correct.
suggested two options.
yes.
We suggested two things. You had yesterday said with regard to registration.
Lord, I'm not on merits. Let me complete my request to your lordships. Lord, I'm not saying that your lordships may not take up or may not stay partly or fully. Lord, even for the purpose of deciding what will be the fallout of your lordship's order, also your lordship will need some documents. I'm saying it with a sense of responsibility, that if your lordships were to say something about the work by user, Lord, what will be the fallout of that? Please hear us, my lord.
So we are hearing you. What will-
Allow me to place, my lord, material on record. My lord, 1 week, nothing would change, my lord. 1 week, nothing can change, my lord.
But then stay off as far as appointment of boards is concerned.
Not make any appointments, my lord. I make a statement.
Appointment of boards and councils is concerned, 1, 2. Number 3 is with regard to work in use, wherever the properties have been already declared as registered properties.
If it is declared, my lord, if it is registered, that's the
No,
distinction.
no, no, one. Registered in terms of section 36 of the 1995 Act. I'm not talking about registration now. I'm not talking about registration now.
Let me take instructions on the last part and I'll possibly able to, my lord, say yes to it.
And
I don't want
there
to
is
change
normally-
position.
Yes, that's all. We don't want the position to change.
Position, government does not want to overreach your lordship's jurisdiction.
No, there's no question of overreaching.
I know, your lordship
And I
is not
don't,
considering.
I do not, we never said, look, parliament makes laws, executive decides and execute the laws, judiciary adjudicates. We strictly go by that. method.
One line, only
But,
one
but,
line.
but Parliament is entitled to a
Correct?
fair, reasonable, it's
Hang on,
Parliament, not
one minute,
will of the people.
One minute.
Will of the people.
1 minute, please.
10 days,
What?
15 days, Parliament will not be given.
Okay, fine.
After 15 days.
Okay, fine. We'll do that. But in the meanwhile, no appointments to
But
the
nothing,
board.
no heavens
I
will
make
fall.
a
Okay,
statement.
fine.
No heavens will fall.
Okay, fine. No appointments to the board, no appointments to the council,
I make a statement.
and no changes as far as
Registered works are concerned.
Concerned.
If, that's part of law. That's part of the law, my lord. And if there is any,
Make us say something about registration. My lord, what is being today said is that hereafter no work will be registered, without registration of the document, it will not be registered
Oh,
by the.
fine, clarify that. So then,
The earlier law
Lord,
is existed
if any,
from 1923, 1954, and penalties were imposable even then. I can. show
not penalty, jail terms.
And
Mr. Ranjit Kumar, please.
so therefore.
Well, Mr. Ranjit Kumar, this is not correct. Mr. Tushar Mehta is on his legs.
No,
Lord, I am only earnestly
1 minute,
requesting,
1 minute. We got no difficulty, Mr. Mehta. We got no-
within a week, my reading of the provision.
1 minute, please. Not
My
like this.
reading of the provision is within a week, nothing can happen even if government wants to. And if not somebody is aggrieved, somebody can always come.
Appointments are not
So,
happening.
1 minute.
Appointment is in my hands, my lord, I can tell your lordship, my lord.
Correct, that is,
No
no,
appointments will-
no, state governments are also there. Your state governments may not be in your hand. The central government is to appoint the bench.
State government.
Please, Mr. Ranjit Kumar, please. You're not representing all the states, are you representing all the states?
Representing some
Correct,
state, I can
correct.
say for my.
So therefore, please, as far as council, can we
But I
have,
can make a statement. If before your lordship hears, if any state which is not represented makes any state appointment, may be treated as void.
okay, fine.
What?
And as far as,
I can't be, my lord, more
correct.
candid than this.
Correct. And as far as the works which have been already declared and registered as, declared on the Gazette or registered as
Yes.
works under section 36 of the,
Of course, that's my assurance to your lordships.
My
Lord use the word
okay, that's fine, please fine. We've got no, look, we are not anxious. What we thought was,
Your lordships are not. Your
we
lordships
also want,
overreach, my lord, the pendency of the petition, that's your lordship's concern.
One additional thing, well, there's one small additional thing. There's an additional thing, 3C12 and proviso. Because they will treat it as not a work. It operates by normal.
No, Dr. Singhvi, once we say that the works which have been already declared to be
Declared and registered.
declared or registered,
And
1 minute please.
Catch here.
They
By user,
declared or
declared or
registered,
All work by user.
1 minute, no, work by users are also registered now.
No,
yes,
That's the problem. My lord used the word or otherwise yesterday. My lord, the Chief Justice used the word for otherwise. That's the correct word because work by user registered may not be registered.
Okay, please, I'm dictating the order, please.
It's my assurance to your lordships.
You must kindly see or otherwise.
Assurance to your lordships.
Give me the indulgence of 1 minute, just 1 minute. Would my lord?
It may not be required. Let me dictate the order, after that it may not be.
My lord, before dictating the order, please give us some time. One sentence from the Ram. We are entitled to be heard with loud respect, I am saying.
Please just.
My lord, with great
During the
respect.
course of hearing, 1 minute
Please
please.
give 2 minutes, my lord, 2 minutes, my lord. I'm not, my lord, I beg to appear for the state of Chhattisgarh, my lord. And your lordships will find it, my lord, quite significant to know that the work board, my lord, of the Chhattisgarh State Board is supporting the legislation.
Right?
Now, my lord, please.
I'm sure there will be Muslim organizations supporting the.
No, my lord. The tenure of the.
But I'm sure there are Hindus who are opposing the.
My lord, the learned advocate general.
Not a religious issue.
Please hear me, my lord, the learned advocate general is here. He's saying that the term of the board is up to 2027.
Please, that's all, Mr. Srivastava, not required. Right.
My lord, please hear us, my lord, at least. my lord.
Nobody will interrupt now.
My lord, only one line. While dictating the order, my lord, please consider, except my lord, the appointment part, the fallout of your lordships.
No, nothing, no, there will be no
Cannot
follow-up.
contemplate.
No, we are not, we know that. Right now,
There is only one, my lord.
please,
Please.
nothing,
What is this?
nothing at this stage. Right now, during the course of hearing, Mr. Tushar Mehta, Learned Solicitor General, states that the respondents would like to put in a response, which will be filed, short response, to reply, which will be filed within 7 days. He further states, till the next date of hearing, he assures the court that no appointments will be made to the council and the board under section 9 and 14 of the amended provisions to stop. It is also stated that till the next date of hearing, the work, including works by use, already registered or gazetted.
Yes, yes.
1 minute, please.
Yes.
Just let me conclude.
I'm sorry. Your lordships are right.
What's-
Gazetted.
Let me concentrate in
My apologies.
including work by use, whether declared by way of notification or by way of registration, shall be notified, neither will the character be changed. Full stop. Next paragraph. We take the statement on record. Full stop. Let the reply, stroke counter affidavit on behalf of the respondents be filed within 7 days. Response thereto may be filed within 5 days thereafter. Stroke service, within 5 days of the service thereof. Full stop. List in the week commencing. May 2025 at 2 p.m.
Intervention. May I have a, there are states
One more
intervention.
thing now, just one, you want to-
State government.
Yeah, for the work-
Intervention by states.
What
What state governments are here?
Yes, states and
I'm,
work.
please, I'm coming to the logistical issue. Just one. As far as the writ petitioners are concerned, I want only 5 writ petitions to remain in court. We cannot have so many.
That's fine, Buzz. We'll organize that.
It will be impossible for us.
We'll
also-
organize that.
It's impossible for us also to read 110 or 125.
object.
That's
and
not
it
it.
is-
We'll organize amongst ourselves.
Please
Buzz.
take- Just one.
Same point.
We only want 5. We would have preferred fun, but possibly this may not be possible. You select the 5. Others will be treated as disposed of or will be treated as. Just 1 minute, please. Can we have some decorum in the court? We only want 5. Whichever one you select, please select and inform them within 1 day. Maybe by Saturday, you inform them that these are the 5 which will, other writ petitions will be treated as either applications or should be treated as disposed of wherever you. And we are not going to now mention the name of the parties. They will be all referred to, the writ petition will be referred to
Work
as
amendment bill.
in the work amendment bill. By work amendment act.
That's right. Kamala, may I have?
If there is a writ petition challenging the.
2 minutes. Let him say 2 minutes.
Nobody will say anything.
2 minutes each.
Without, nobody will say anything. This is not a place where you can.
One submission, my lord. Not only one submission.
1 minute, please. That's it. I don't want any more discussion. One, and number 2, please appoint a notary councils amongst yourself to whom all the papers can be given and who will be filing the rejoinder.
Manoj, your lordships have said,
Lord, there is
work
an
by user,
intervention by the-
declared or registered.
May be allowed.
Either declared or registered, Manoj.
Intervention.
Yeah. I just,
Declared or registered, including work by use.
Oh, including, that's fine then.
Including work by use.
That's fine then. Kindly make that clear.
I know what I'm declaring.
That's perfect. That's perfect.
Lordship's item
One more sentence,
57.
one more sentence, fellows, one more sentence. That 3C, 1, 2 and proviso is self-executory when the law came into force.
no, not.
When the law came into force,
We have,
self-ex.
that's all.
Intervention.
Lordship, state government, lords, I'm representing the state government. I'm
1
representing.
minute, please.
Intervention.
May I suggest?
Intervention.
One minute, Mr. Jain. I remember that.
Representation of the states.
Thing I don't remember. It's not so bad.
I'm requesting for the state
1
government.
minute, please. Now 1 minute, please. Similarly, on your side, please appoint a notary
You, me
council.
and including.
Correct?
Including,
And,
yes.
on your side, please give us the list of councils.
Will
who
do.
will be arguing.
Yes, we'll do.
And the list of councils who will be arguing.
Lord,
We can't allow
I
everybody
agree,
to argue.
Manoj, we'll do that.
We cannot allow everybody to argue.
Interventions may formally be allowed. Item 57, my lord, is a substantive writ.
Instead of disposing the.
State governments have a stake in the matter. They should have been.
Let the petition remain.
Five council will argue only. That's much
That
better.
my learned friend is right. 5
Lordship's
councils.
item 57.
Right out. It is agreed by the council for the petitioners that they will identify 5 writ petitions which will be treated as lead cases. So other writ petitions will be treated as applications filed in those writ petitions.
Lordship's item 57 is a substantive writ, my lords.
1
Substantive
minute,
writ.
please.
Let the writ petitions remain, which will be 5 councils. Because now, the point is, it may not be in the main petition, but there are non-Muslims who have been excluded.
Only 5 council will argue for us.
No, Mr. Dhawan, I'll tell you the reason. No, Mr. Dhawan, I'll tell you the reason. The difficulty is with this large number of petitions and continuous flow of petitions even today. I've marked some case matters for 28 today also.
Well, it doesn't matter. We'll argue that question of law in any case.
You can argue the question of name.
My lord, now, no,
Lordship, the substantive challenge to the 95 Act is there in item 57, my lords, on threshold of secularism.
1 minute, please.
Sharia is being applied to the state lands, my lords, in non,
We are aware of that.
those may be kept upside, my lords.
those will come from both sides so that it is legal organized.
Right on. The writ petition challenging the amendments made, the earlier amendments
The 95 Act.
The 95 Act.
The 95 Act substantive.
1995 Act and 2013 Act, both are under challenge or only?
95 substantive,
Challenging.
item 57.
95 is a substantive act and
95 Act still exists.
Can I
Let us-
dictate,
let us
please?
put it down.
Can I dictate? The writ petitions challenging the WAF Act, the WAF Act 1995 and the amendments made in 2013 shall be drawn.
I'm grateful.
What's this? So stop. It will be open to now, Mr. Mehta,
Mr.
which
Ajaz.
way will you filing the reply?
Your lordship may fix the date. I'll not seek extension.
No, will you file the reply to that?
I'll not wait for them to select 5. I'll keep the title blank.
Okay.
My affidavit will be
Okay,
ready.
will be separately shown in the cause list. Liberty is granted to the petitioners. As a special case, liberty is granted to the petitioners who have filed writ petitions challenging to 2000 amendment to file response to the said writ petitions. Stop. The Union of India and other response. State governments may also file reply to these writ petitions.
And
within-
work boards.
And the work board may file reply to these writ petitions within period of reply to these writ petitions within period of 7 days. Full stop. Rejoinder if any, within
Lordship.
5 days service of the reply stroke counter affidavit.
Lordship.
Full stop. Next page, next. The, as a, both the sides, that is the petitioners and the respondents will appoint nodal counsel, whose service will be effective. The details of the nodal counsel will be
Mr.
furnished.
Not Mr. Kanu Agarwal on our side.
Just give it, the details
We'll
of
give it,
the,
we'll give it to them.
okay, both the petitioners and the respondents have appointed nodal counsels for effective service and for filing of pleadings. The name and details are as under.
Right.
Just wrote right now. You also gave your nodal
Yes,
counsel.
Mr. Vishnu Jain, my lord.
As far as the reply by work boards is concerned, there are so many work boards.
Let them,
that
let the,
the Indian government.
let them, if somebody wants to, the,
He talks about the scheduled tribes protection. But I am representing those scheduled tribes, not who have, so but
I said, fine, no, not required, will be only a preliminary, it will be hearing will be a preliminary hearing for directions and if required, an interim order.
Obliged, deeply obliged.
But
Deeply
now,
obliged.
on the lighter side, the lordships have changed the name in Ray so-and-so. Now new petitions will change the name in Ray so-and-so. Now new petitions will stop.
Very deeply obliged.
The cause title in all the writ petitions would read as in Reg 2025, the Work Amendment Act 2025, 1, 2, 3, 4, 5.
Obliged. Very deeply obliged.